Hi, welcome to Law Ignite. Have you ever signed a deal thinking it was legit, only to realize it was totally invalid? What if I told you a company can make promises and still legally not be bound by them? Welcome to the mighty and overlooked legal doctrine that can destroy or create a company. The Doctrine of Ultra Vires. Let's get into it, with emotion, illustrations, and a story you won't forget. Imagine this. A company called Dream Build Limited, which has registered to produce green furniture, goes and signs a multi-crore agreement to build a luxury resort out of the blue. Thrilling, isn't it? But when the go is bad and investors file a lawsuit for losses, the company just says, "Sorry, we never had the authority to do this in the first place." Stunning, but absolutely plausible under the doctrine of ultra vires. See? Ultra vires means beyond the powers in Latin. In other words, if a company does something that is not within the objective stated in its Memorandum of Association, MOA, then it's said to do something ultra vires, and such an act is void. Think of it this way. You're a chef, hired to cook, but suddenly your supervisor asks you to pilot the company plane. Even if you agree, and even if you do your best effort, legally, you cannot do it, because it's not what you're hired to do. That's what ultra vires is for companies, doing something that they were never hired to do. Okay, let's get a little technical, but not too hard. According to company law, the Indian Companies Act, every company is required to register a Memorandum of Association, MOA. It specifies what the company is formed for, the ambit of its powers, its purposes and aim when the company acts according to the MOA, intra vires, valid when the company acts beyond it, ultra vires, invalid and void, and no resolution of the board, no vote of the shareholders, not even the government can authenticate an ultra vires act. Okay? One of the most famous cases? Ashbury Railway Carriage Corvier Rich, 1875. The firm had a specific goal to produce railway carriages, but they entered into an agreement to fund the construction of a rail line overseas, completely beyond their MOA. The court declared ultra vires, and therefore void. Shareholders may have wanted it, but the law did not permit it. Today, in the startup ecosystem, business is swift and innovative. And yet even today, the doctrine of ultra vires safeguards investors, buyers, and the market from businesses promising too much and delivering too little beyond their legal powers. It keeps the system in check. So, next time you see a company making bold moves, ask this: is it really allowed to do this? Because if not, the doctrine of ultra vires could very well break a dream that was never legally attainable.